Chair, if you may seek the indulgence just to talk about, again, subpart 3. This is the Register of Licensed Auditors and Registered Auditing Firms. As mentioned, I think this is a very important clause actually because I think it's a great idea personally. And this is subpart 3. We're basically talking, it's starting at clause 29, and what it basically says is that there has to be a register kept and maintained of licensed auditors and registered audit firms. The registrar must establish and maintain, in accordance with this subpart, a register of licensed auditors and auditing firms. But again, Mr. Chair, I have a slight issue around, if we go down to clause 30, part 3, where it says, well, this is clause 30 is the operation of and access to the register, which makes sense, it's got to be there. A register may be kept as an electronic register or in any other manner the registrar thinks fit. Makes sense. But then it says the register must be available for access and searching by members of the public unless suspended by subsection 3. Now, I'm not too sure what that means, Mr. Chair, because when I look at subsection 3, it says the registrar may refuse access to the register or otherwise suspend the operation of the register in whole or in part if the registrar considers that it is not practical to provide access to the register or for any other reason that is prescribed by the regulations. Now, again, I have a little bit of difficulty with the language used here, Mr. Chair. I'm just wondering under what circumstances would the register decide to actually refuse access to this, and what is the test for the practicability? What is not practical? Does that mean if a bloke comes in at 4 o'clock on a Friday and the guy's got a game of golf at 5:30, as far as he or she is concerned, that's not practical? I'm using a ridiculous example here, Mr. Chair, but again, this has not been quantified, and I think that probably the investing public wouldn't mind knowing what that practical test is, because it's quite important. It's quite important, because if we go to clause 31, it talks about the purpose of a register. And the purpose of a register is actually quite important. It will enable any person to determine whether a person is a licensed auditor, and if so, the status and relevant history of that person's licence. Makes complete sense, because as we say, it's about transparency now, it's about knowledge, about getting out there. If I want to know a person who's come to me and wants to audit my firm as a licensed auditor, it's only fair and right that I should be able to go somewhere and determine if this person is telling the truth. Or for another reason, if I want to find a registered auditor, maybe I can go to the register. But if the registrar considers that it is not practical to provide access to the register, what does that mean? I turn up and he says, sorry sir, that's not practical. That's interesting. It would have been good just to have that quantified a little bit more. But now the purpose of the register. There is one thing here, Mr. Chair, that sets off a little bit of alarm bells for me. If we go down to the purpose of the register, the last part 3 there, know which licensed auditors, this is the purpose of the register, know which licensed auditors have been disciplined within the last 7 years. Now I thought this is very interesting, because before we talked about fit and proper persons to become a registered auditor, but now this implies that in fact an auditor can be disciplined within the last 7 years. And again, I'm wondering, and it may be set out in this bill, like I said, it's a 100-page bill, there's a lot of work here. Under what conditions can an auditor actually be disciplined but allowed to remain as a licensed auditor? Now, I'm assuming it's not fraud. I'm assuming how this process works is that a person puts a case towards a relevant authority. I assume in this case the Financial Markets Authority. Their complaint is heard, and maybe the Financial Market Authority disciplines this person. That might be over the size of the bill. But if it's a really serious consideration around fraud or negligence, if the person has been disciplined, is there a process of expelling that? And I would have thought that if a person had been disciplined, then they would not actually fit the fit and proper person test. Maybe I'm wrong, and maybe I'm being a little bit too hard, but as mentioned, the role of the Financial Markets Authority must be to restore the confidence of the investing public in our financial markets. And maybe, again, this is where it becomes practical. If someone complains to the registrar, look, this is unfair, it breaches my privacy rights, that it says in here that I've been disciplined and I don't want people to know that, then maybe that's a practical test. But again, I'm just making a whole lot of assumptions, Mr. Chair.
The Honourable Dr Wayne Mapp.
Chairman, I just thought